Well, I think it requires kind of a detailed analysis, so if I may.
Sure.
All right, so the first thing we have to decide is whether or not, and we're talking about President Trump, we're not talking about the actions of others. We have to look and see whether or not that which has been alleged as facts is in fact core political speech, political discourse, protected speech at its zenith. I don't think there's any question that statements, comments, speech, expressive conduct that deals with campaigning or elections has always been found to be at the zenith of protected speech. What do we have here? We have election speech. So one must determine immediately whether that constitutes core political speech, and I suggest that it does. Now, does that make a difference ultimately? Yes, because the more core speech, the more it is protected, the less the government should be involved in restricting it. I don't think there's any real doubt about that. So then the question becomes, is the mere fact that the state here represents that it is false or fraudulent under the statute, is that enough? Now, from what I just heard, I think the state's position would be yes. All we have to do is say it's false, it's integral to criminal conduct, it's fraud, and therefore it can't be unconstitutional as applied. I don't believe that that's what the law says. I think what the law really looks at is as to each individual application of a statute, whether or not the falsity in and of itself alone is sufficient. And I think the case law indicates that that's not so, particularly, and I don't need to go back through in detail everything that Alvarez said, but I think Alvarez is important because even when you talk in terms of, and I'll start with we're looking at the majority, what I guess it would be the plurality opinion, that by Judge Kennedy, but for purposes of interest to us, the Chief Justice and Justice Sotomayor agree. So now we're talking about two people still on the court. And I'm looking specifically at page 723, in which the court goes on to say, were the court to hold that the interest in truthful discourse alone is sufficient to sustain a ban on speech, absent any evidence that the speech would be used to gain a material advantage, it would give government a broad censorial power unprecedented in this court's cases or in our constitutional tradition. So that's the beginning part of plurality, saying the way to attack false speech or false political speech or core speech is with truth, which is precisely what was going on. We're talking about this time period without getting outside the indictment. You're talking about at the same time the allegations are being made, factual allegations in the indictment, you have others that are fighting that off. Government's position would be with state's position with truth. Moving beyond Alvarez, that part of it, you have Justice Kagan with Justice Breyer. And here I think gets to the crux of where we are. And this is the concurring opinion. It goes through a litany of false statement cases in which the government's position in Alvarez is being false in and of itself is enough. That is, once you determine it's false, we're done. But that's not what the concurrent says, and that's not what the dissent says. The concurrent says, basically, that these judicial statements cannot be read to mean no protection at all. False factual statements can serve useful human objectives, for example, in social contexts where they may prevent embarrassment, in public contexts where they may stop or panic in the face of danger, and even in technical, philosophical, and scientific contexts where as Socrates' method suggests, examination of a false statement, even if made deliberately to mislead, can promote a form of thought that ultimately helps realize the truth. And then it goes on and says, even a false statement may be deemed to make a valuable contribution to public debate since it brings about the clear perception and the livelier impression of truth produced by its collision with error. So this is the proposition that it's not the falsity alone that controls. It's the context in which the speech is made. And if it is deemed false, and for purposes of the indictment, we have to assume that it is false because that's what the facts have been alleged. That doesn't mean it's the end of the analysis.
Why do we not also have to assume, since it's an allegation, I think you say in your brief, that it's unlawful, willful, and knowingly false?
Because at least our position, President Trump's position is those are not words of fact. Those are words of legal connotation. And that while they have meaning, that would allow, for example, let's go to Alvarez and the Stolen Valor Act. Just because they alleged that it was unlawful didn't mean it wins. That is, it doesn't mean that the government wins.
But that's because they decided that wasn't a crime at all. I mean, that was a facial challenge where they said this statute, even if you violated it, violates the First Amendment. You've said that the RICO statute, you can violate it and not, it's not a, right? So we put legal conclusions in indictments all the time. I think that's going to be part of Mr. Schaefer's argument in just a minute. I mean, you said a moment ago, just because the state pleads it, you don't think that's enough in an as-applied challenge, and I'm trying to figure out
as to statements such as legal conclusions are unlawful and so forth. Now, if there had been, I guess, if the allegations had been broader, maybe we wouldn't be at that crossroads. But those aren't facts. The facts, as I've outlined or we've outlined in our brief, you take the overt acts, you look at those overt acts, and then those. At the same time, and then look at the substantive offenses or conspiracy offenses in the rest of the body of the indictment. Words like unlawful don't change that. At least that's our position. So now we're talking in terms, going back to Alvarez and the concurring opinion, you're talking in terms of falsity alone is not enough. There are situations, contexts which override just the falsity alone. And that, again, the political discourse, the political speech, the more significant it is to certain issues, clearly being president of the United States at the time, dealing with elections and campaigning, calling into question whether what had occurred, at least in the election of 2020 for president, that's the height of political speech. And then you go even to the dissent, which I think is as important, because now you have Alito and Thomas and members of the current court. And I go to that. What I believe starts at page 751. And it says, even where there is wide scholarly, and this is 752, even where there is a wide scholarly consensus concerning a particular matter, the truth is served by allowing that consensus to be challenged without fear of reprisal. Today's accepted wisdom sometimes turns out to be mistaken, and in these contexts, even a false statement may be deemed to make a valuable contribution to public debate, since it brings about the clear perception and livelier impression of truth produced by its collision with error, citing U.S. Supreme Court. That's the essence of what we have right here. That's the facts that have been alleged. Essentially, the state's position is, because, as alleged, what President Trump said speech-wise or expressed either through his speech or conduct, which is still freedom of expression, because that's false in the eyes of the state, it's lost all protections of the First Amendment. And the concurring opinion and the dissenting opinion in Alvarez suggests just the opposite. If anything, under the circumstances, it needs more protection, not less protection. So keeping that in mind, let's move to not RICO. Put RICO aside for a minute. Let's move instead to the conspiracy counts, which are counts 9, 11, 13, 15, 17, 19. Basically, what the state's position is on that, because it took this position previously in its filing on September 27, 2023, in response to that which was filed by Chesbrough. And I'm aware, of course, of the court's order that dealt with Chesbrough, and it didn't deal with the as applied. So I'm dealing.
And more so in that one, as I go back and look at it, there was a much more kind of concerted effort to bring in facts outside of the indictment, right? And they started talking about, well, there was a transcript at the meeting, there was this, so it didn't really seem to be a true as applied challenge, right?
But as the court noted in its order, at that point it didn't determine that it was ripe for a pretrial challenge. So I'm taking what Chesbrough, what the state said, as it applies now, because it says in that brief that it was both as to facial and as applied challenges. Essentially what it says is, as to those counts, 9, 11, 13, 15, 17, 19, as to 9, 11, and 17, the mere fact that it alleges a fraud is enough. That's what's on page 5 and page 6. Since each of those statutes prohibit conduct involving fraud, we don't go any further. And I'm suggesting that's wrong, that you must go further. You must look at the speech itself, the expressive conduct itself in connection with those specific statutes. That's what the as applied is. The fact that it's a fraudulent statute, now you want to look and see why, under the circumstances here, the language speech of the president falls within that. And if you look at it in that sense, the mere fact that it's false is all that they have. There's not a finding that the speech itself, beyond the speech itself, is fraudulent. What the state wants to do is say, we have a goal. We have an objective here that we have put forward. Steal the election in an unlawful fashion. I say change that for a second to legitimate concern about the validity of the election. If that was the way you focused on it, which is a way to do it as applied, even with the facts, would what President Trump said on those counts be a protected speech? And the answer is it has to be, because the only thing that makes it fraudulent is the state saying it's false. Take every one of those and say, okay, it's not false. It's protected. The only reason it becomes unprotected, in the state's opinion, is because they call it false. And that's what Alvarez doesn't allow. In and of itself, it cannot be simply the content-based. It has to be contextual. And the contextual here is a political core value being addressed, elections and campaigning. And that holds true for all of those that deal with the conspiracy. And then you deal with counts 29 and 39, which is the false statements charges. Now, it is clear that the Supreme Court would find that a statement made under 1001, 18 U.S.C. 1001, would constitute the appropriate, let's say, abridgment or non-protected conduct or speech. But Georgia's statute's a little different here, because we don't have a materiality element. It's the mere fact of falsity, which violates, according to Georgia law, counts 29 and 39. You don't have to do anything else but make a false statement, even if it is political discourse, even if it is in the heightened context that I've suggested. If it's false, it's a violation of the law. And I'm saying, as applied to political speech, that can't be constitutional as applied. Remember, no materiality, simply the fact that he said it. So essentially, what the state's position on that would be, it didn't have to be sent to anyone of consequence in the state agency. It just had to be said. Indeed, if you look at, and the most probably best example is count 39, that's a letter written after the election in September of 2021 from President Trump to Secretary of State, in which it has, according to that, one statement, and that constitutes, according to the state, falsity, but it's clearly political speech, and it's clearly being related to the activities and the matters that of election and campaigning. Even after the fact, it's still related just to that. So looking at 29 and 39, I think you have a situation in which the falsity alone is all they have as applied here to political speech. It is unconstitutional as applied under the First Amendment. And then finally, you have count 27.
Quick question on that. Had you, I hadn't located one. Had you found anyone ever attempted a facial challenge on 161020?
Yeah, in fact, I don't remember the name of the case, but it has been upheld, even though there was references to the fact that maybe materiality should be part of it.
That's got to be the Haley case. That's right. That's right. Okay.
So, yes, facially, yes. But Haley, of course, didn't go to the extent of trying to determine as applied in a particular context. And it's, again, I don't to repeat what I just said, but here we're talking about the heightened value of core political speech. And then with 27, we're talking about the filing of a false document. Again, the only thing there that involves President Trump is an attestation on the complaint. Now, all it refers to in the indictment is complaint. But again, we're talking about the act, the falsity, or the filing of a false document is the falsity in the document itself. And I'm suggesting under the circumstances that, and that alone, wouldn't violate that statute as applied. So regardless of the facial challenges, the question becomes here, is the mere fact that the state says fraud or false statement enough to get by an as-applied challenge? And our suggestion is it is not. Now let's go to RICO.
You're watching a courtroom in Georgia where former President Trump's attorneys are asking the judge to throw out the election interference charges against him in that state. Let's bring in ABC News executive editorial producer John Santucci, along with ABC News contributor, former Georgia prosecutor Chris Timmons, for more. Chris, Trump's attorneys are arguing here that the indictment is unconstitutional as it applies to this case. What does that mean?
So what it's saying is you've got two types of constitutional challenges when it comes to criminal laws. One is what's referred to as a facial challenge. You're saying that the law itself is unconstitutional. Like somebody passes a law that says that it's illegal to burn a flag. That would be facially unconstitutional because flag burning has, as we've seen, First Amendment protection. The other one is as applied. Let's say it's something along the lines of, it's illegal to burn a cloth. Well, then if you turn around and say they're burning this flag, that would be, and they're prosecuting these people on behalf or because they're burning that flag, that would be as applied. In other words, the law itself, burning a cloth, that's no problem. But as you're applying it here, meaning that you're making it illegal to burn a flag, that would be unconstitutional. So one is facially when we're talking about the law itself. The other one is as applied. That's taking a law that would otherwise be neutral and would not be a violation of constitutional law, but you're applying it in a way that violates someone's right to expression. And here what they're talking about is facially there's no issue with the RICO Act. They're sort of arguing that facially there might be a problem with the false statements. This statute that says that it's illegal to make a false statement to the government, they're saying that there might be a facial issue with that, but by and large what they're saying here is that these laws are, as they're applied to the former president, they would, and all of the defendants, frankly, but these laws as applied here would be unconstitutional because they're chilling or they're criminalizing their protected speech.
John, what are Trump's attorneys trying to accomplish here, not only in terms of the case, but also knowing that so many people are watching this and how it's playing out?
So I think, there's been a lot of lines from Steve Sadow throughout this trying to make it clear that the statements by Donald Trump was Donald Trump talking about the election, which in his argument he has the right to do. There's a line that our team pulled out immediately from State Island. It's the following, quote, "I don't think there's any question that statements, comments, speech, expressive conduct that deals with campaigning or elections has been found to be at the zenith of protected speech. What do we have here? We have election speech." That is the argument, right? That Donald Trump, as a candidate for office, had the right to make comments about the election. That is where they're going to drive his argument home, that he wasn't trying to push people to overthrow the government, charge the Capitol in D.C., or to approach ballot locations, as we know they did in Georgia, trying to capture votes, right? This was all Donald Trump doing what he believed was in his interest, both as president but as candidate, to call out what they say he believed at the time was fraud. Now, having said all of that, right, to answer your other part of your question, what are they trying to accomplish here? They're trying to make this thing go away, right? They're trying to make it delayed. They're trying to use the idea of Donald Trump's key argument here, which is election interference, witch hunt, etc., all charging into the next election. So they need to do as much of these items right now, which are delayed tactics, to get the ball further down the field. But the other thing that they are avoiding, which I'm sure when the prosecutors get their turn, because the defense is going in part so long because this is their motion, the prosecutors need to actually pull Donald Trump's words. And that's what matters, right? In the case of Georgia, center to this case is the phone calls and actions Donald Trump, Mark Meadows, Rudy Giuliani took trying to push state officials to violate their oath of office. Now, we know, Diane, that a lot of the indictment counts that were originally imparted last August when Donald Trump and 18 others were indicted were those actions, right? The judge taking some of those away, saying that the DA's office did not have enough evidence as part of the original indictment that they were forcing these individuals or coercing them to violate their oath of office. We have not seen the DA's office try to refile those charges. So does that happen now that the case is back on track? Possibly, but nevertheless, all of this is, frankly, it's interesting real-time theater in some ways into how lawyers try to get their case shifted and changed. And I think we've all seen this evolution. Just look at that example we just talked about. The fact that we had a bigger indictment, Donald Trump losing originally 13 counts of this indictment down to 10, that is a win for the team, and that's what they're going to try to keep doing here.
Chris, that phone call between Trump and the Georgia Secretary of State is really at the heart of this case. And you can hear Trump on the recording of that call asking the Secretary of State to find the 12,000 votes he needs to win. So how are Trump's attorneys going to defend against that? Can they say that that is political speech?
I mean, that's exactly what they're saying, Diane. They're saying that it's political speech when he told Brad Raffensperger to go out and find those votes. They're going to argue that they didn't, make up those votes. They're going to argue that what they were telling Brad Raffensperger to do was do your job. There are these votes out there, these 11,000 votes that are improper, or 12,000 or 13,000, however many we're talking about. But there were these fraudulent votes that were cast, and the president says go find them. Now, there's different ways that this is going to be cast by the different parties. The president's team is saying, look, those were fraudulent votes, or at least we thought those were fraudulent votes at the time. So we were just telling him to go out, do your job, establish the fraud that we think is there. The way the state is going to characterize it, that same phone calls, they're going to say, no. He knew that there were not fraudulent votes out there. What he was telling Brad Raffensperger by find those votes, meaning like declare certain votes that were proper votes to be improper votes to be fraudulent. And so that's really at the heart of this case. What the defense is saying is that when he said that was protected speech. He's just trying to redress a grievance with the government. That's in the Constitution itself. It says that if you petition the government, you've got absolutely a protected right to do that. And what the state is saying is that, no. You can't go to the government and petition the government with your grievance when you know what you're saying is false, when you're trying to get the government to commit a crime, Diane.
But, Chris, how tough will that be for prosecutors? Because essentially to win that argument, they have to prove intent. They have to prove what Donald Trump intended with those words and what he meant by those words, rather than just being able to look at the words and blatantly let them state it for themselves.
Right, Diane, I've tried a number of false statements cases, and they are difficult because, we don't have some sort of magic machine where we can go back and figure out exactly what someone was thinking at the time that they said something. I think there's a couple parts here. They're going to say that Donald Trump had been told over and over and over, look, man, you don't have it. I mean, there aren't these fraudulent votes out there, and a number of different people told it. But I mean, one of the things, and John Santucci can tell you better than anyone, is that Donald Trump doesn't very often listen to other people when they're counter to exactly what he's thinking. So the argument by the defense is going to be, look, he may have been wrong, but at the time that he was doing this, he thought he was right, and who cares what anybody else is saying? This is Donald Trump. This is somebody who does not listen to other people when it goes against his instincts, when it goes against things that he thought that he knew, Diane.
John, what are you watching for as this hearing continues?
So I think it's interesting, right? Because we've now seen Judge McAfee several times over the course of the last nearly year over these hearings. One thing I think we know is not going to happen, I can throw this on the board, he's not going to rule today, right? I think we've seen this judge now. He takes these hearings under advisement. So I think the question will be, how quickly does he rule, part A? Part B, what I'm wondering is, what this judge has done, and Chris, I wonder if you agree with me on this, but more often than not, he sort of has given us a little sense of where we're going next on the road. And what I mean by that is he going to ask for more, arguments? Does he want to see more motions? Does he want to see more documentation? Does he talk at all about the efforts for the appeal to disqualify the DA? I think really, given that this is the first time they've all been together again since the efforts to disqualify the DA failed, I'm sort of curious what the rules of the road are going to look like. Because for the moment, we know the DA has indicated she wants to double down and head to trial come August. Do we get any of those tea leaves in a hearing like this today? Because again, they're all together. I'd be curious.
Chris, you know this court system firsthand and the players involved. What do you think?
So, I mean, John is right. We are going to get a little bit of a glimpse as to what's going forward. In terms of what he's thinking on the disqualification and how he's going to handle it, I mean, it's obviously it's the elephant in the room. It's what everybody wants to know, who is going to be the prosecutor in this case. And, as interesting as the First Amendments are, I mean, that's just overshadowing everything, and is probably the most interesting piece in all of this right now. Is Fani Willis going to continue on with the case? I don't know if he's going to address it today. I mean, he sort of hinted at it a little bit by he's continuing to move forward with these cases. I think if he thought that he was going to get reversed at the Court of Appeals, he probably would have stayed everything and wouldn't be hearing these arguments today. So I think he's confident in his ruling. But in terms of saying anything about it, I don't know. He probably also won't give us a court date just yet. Because you would think, although, who knows, we've been surprised a number of different times in this case. But we haven't heard back from the Court of Appeals yet. So it'd be difficult if he set a court date down for August and then a new prosecutor has to be appointed to this case. And, if for whatever reason the Court of Appeals decides to overrule Judge McAfee and decide that Fani Willis should be disqualified and her entire office along with her, then at that point this case stalls out while it goes to the Prosecuting Attorney's Council to decide exactly who would take this case and take it forward. So John's right. I mean, we are going to see a little bit more. This is a judge who tends to tell us which direction we're going, but I'm not sure if he'll go quite as far as setting a trial date today, even though that's the other thing we all want to know, which is when is this going to play out? I mean, we know New York is going in April. It's going to start out on tax day, April 15, which is going to be just fascinating. The first time the former president goes to trial in a criminal case. But the other thing they want to know is when is Georgia going? Because Georgia is going to probably be the most interesting of all these cases, because we're going to have live television just as we do right now. That's something that's unheard of in most courts. New York, what we're getting are pictures and recounting by people who are in the courtroom. In Georgia, everybody's going to be able to see it for themselves. And so that's going to be the type of television that's going to be must-see TV. I mean, people definitely are going to tune into that. So we want to know, when should we block our calendars out? When should we know that this thing is going to trial and we're going to be able to see it, Diane?
All right. And let's listen back into the courtroom as the state makes their arguments.
Thoroughly addressed does not change the fact that it can be employed as part of criminal conduct. The mere fact that you're talking about issues of public concern or core political speech, which may be completely fine and protected in most contexts, does not mean that you cannot be indicted if you use that kind of speech to pursue illegal activities. That's the whole nature of the question. So it's very circular, and I would direct Your Honor to page 6 to 7 of the post-hearing brief filed by Defendant Trump, which says, the speech integral to criminal conduct exception of the First Amendment does not apply here because all the charged conduct constitutes First Amendment protected speech. That is a very neat circle. The First Amendment protects us because all the speech is protected by the First Amendment. And in the end, no matter how much we hear about the, obviously the noble protections afforded by the First Amendment, all of this is an effort to get Your Honor not to look at the basic fact that this speech, this expression, all this activity is employed as part of a pattern of criminal conduct in a host of ways. And because Your Honor is bound by the indictment and has to look at the indictment and can't look beyond it, if we're going to get into this at this stage, then there's nowhere to go, as I said at the beginning, because this is all alleged as part of a pattern of criminal conduct and not protected by the First Amendment. Any argument to the otherwise is just to try to pretend like that's not true.
All right. Thank you, Mr. Wakeford.
Thank you, Your Honor.
Your Honor, may I add one point briefly?
Sure.
Thank you.
Wait a second, we're being doubled up on here?
This is not a trial. I think you can handle it, Mr. Sadow.
And this is, I'm just going to be on one specific point, not duplicate the argument made before. I believe Defendant Trump fundamentally misunderstands the role of an overt act in a conspiracy case. As we've discussed many times previously, this is a RICO conspiracy case. And so we heard Mr. Sadow discuss various overt acts and say, well, but this is just a tweet. This is just a phone call. This is just X. The unspoken underlying and incorrect premise then is that every overt act must be a crime. As we've discussed a number of times, and as the state has set forth extensively in multiple briefs, that's not true. The purpose of an overt act is to show that the conspiracy is an operation. It is not a separate crime. It doesn't have to satisfy the elements. It doesn't have to be pled with that level of detail, as Your Honor acknowledged in an order I think that's all of 2 weeks old. And so to say we can't mention this particular act or this particular conduct because it's not a crime or it's protected by the First Amendment, the answer to that is actually, so what? Because it could be legal conduct, it could be First Amendment protected conduct that also shows there's a conspiracy in operation. And that's, as long as it serves that purpose, it's fine. And so overt acts should not be examined by a standard that has no application to them. They are not separate freestanding offenses. And there is federal case law that, if need be, we can cite it to you, that has said an overt act can involve First Amendment activity. Its purpose is not to be something that is separately charged here, separately subject to a separate sentence. Its purpose is to show that there is a conspiracy and it's an operation. Georgia RICO requires one overt act by any one defendant. So, of course, the RICO would stand if anything, any of the 161 overt acts alleged constituted an overt act. It would only take one. It doesn't take any by Mr. Trump. But the point is, we have an abundance of them by Mr. Trump, and for purposes of the RICO statute and the manner in which it functions, it doesn't matter whether that's First Amendment conduct or not. I mean, my colleague has fully explained why much of this conduct is not shielded under any circumstance by the First Amendment, and I don't mean to contradict that in any respect. But it's important not to lose sight of the function the overt act plays, the role it plays in a conspiracy case here, because it is not the role being suggested by Defendant Trump.
All right. Thank you, Mr. Floyd. All right, Mr. Sadow, I'll give you a couple minutes. Final word.
Thank you, sir. If I heard what Mr. Floyd just said, that if everything President Trump said was assumed true and included in the RICO indictment, and therefore now we're talking about true political speech, not alleged false, he could still be prosecuted for the violation of RICO.
For the overt acts as alleged. Let's say even the overt acts ran afoul of the First Amendment. He's saying that wouldn't be fatal to count one.
Because at that point, if there
could be some other thing they prove that's not alleged as an overt act.
Okay, that may,
as I understand it,
as I understood it as well. But what I'm suggesting is, if all of the overt acts are nothing more than core political speech or expressive conduct, and nothing else is alleged which is not protected by the First Amendment, then you have an insufficient basis for which he has been indicted, because he's being indicted for First Amendment speech and not for unprotected speech. And therefore, the statement that was made about if it were true, we could still use it as an overt act, suggests that they can prosecute true speech, which is what we're trying to get to here. It's the nature of the speech, the political speech, the heightened value of such, which gets this situation different than others, and the fact that it comes from then President of the United States. Going back to what was said in addition by the state, what the state claims is criminal here is lying to the government. That's what it said. That's the exact reason why in several of the Supreme Court cases, it's been found to be protected speech because it deals with the government, and falsity in sense of communication with or to the government is best dealt with through true speech, not through prosecutions, because prosecutions chill speech. And when it comes to political core speech, what you don't want is chilled. Fortunately, I have a co-counsel that is able to pull things up and help me inform the court until the computer shuts down. And looking at what Haley says, just to give you an idea of how the Georgia court, the Supreme Court, might look at this. There's a quote from Haley, and it says, "While there is no constitutional value in false statements of fact, such erroneous statements are nevertheless inevitable in free debate, and punishment of error runs the risk of inducing a cautious and restrictive exercise of the constitutionally guaranteed freedoms of speech and press. Accordingly, the First Amendment requires that we protect some falsehood in order to protect speech that matters." And I think that's what we're talking about here. To end this, and again, we're focusing on President Trump's conduct at the time that he, in fact, is the head of the executive branch. There is references to this in Brown v. Hartledge, and I cited that earlier. A well-publicized yet bogus complaint on election eve raises the concerns that you may have some impact that would affect an election. But the preferred First Amendment remedy of more speech, not enforced silence, has special force. Underlying our dependence upon more speech is the presupposition the right conclusions are more likely to be gathered out of a multitude of tongues than through any kind of authoritative selection. To many, this is and always will be folly, but we have staked upon it all. And for speech concerning public affairs is more than self-expression. It is the essence of self-government, and that comes from Garrison v. Louisiana, which is cited also in Alvarez. Bottom line here is this. But for protected First Amendment speech, President Trump would not be charged in RICO or the other counts. Take out the protected speech, and you don't have an underlying basis for which to charge him. And since that violates the Constitution as applied to the charges here and his speech here and his position here, this is ripe for a constitutional challenge. One step further. If it's not ripe now and we get into intent, when does the court determine that? Do you determine that after we have a trial?
I think it would be the directed verdict stage.
Well,
right?
but would it? That's a sufficiency of evidence.
With all inferences, in favor of the state.
That's a whole question. I mean, do we go through the whole trial? God forbid there should be a conviction, and then we go back to trying to determine as applied? I'm suggesting the reason it's ripe now and the reason why we don't even get to a trial is because it's unconstitutional to force an accused, be it the President of the United States, former President, or anyone else, to stand trial on protected speech. And I think that's what Alvarez and the progeny previous to that and after say.
All right. Thank you, Mr. Stadow. All right. Mr. Gillen, do you need a minute before we dive in, or can we get started?
No, we're ready to go.
Okay. So just teeing this one up. I know there's a good bit of your motion that goes back into a lot of ground I think we covered at the December hearing.
Well,
excuse me,
let me start off with some good news for the court.
I'm happy to hear it.
See the smile already on the court's face.
Well, cautiously
our general and specific demur, a great deal of that does go into the areas of RICO that the court has not only ruled on but heard other arguments.
Well, I haven't ruled on it yet, but it was just we talked about continuity.
We talked about in October the 17th ruling addresses some of the issues that were addressed. So I'm not going to replow that ground. That the court has heard. I'm aware of the government's position. I know that probably ruined Mr. Floyd's day by not allowing him to get up and go back over his RICO expertise. I'm not going to do that. What I'd like to do, though, today is to move forward to some areas that I do think needs to be. And the question really, when the court said, do we want to have oral arguments today or not? And then the question was, well, because on the RICO thing, I think I probably could have said, if it was just the RICO component, I would have said, fine, let's just do it on the papers.
You've got a lot of other counts.
There's some other things that I wanted to talk about and have the court focus on as it relates to some of the other aspects of the demurs, special and general demurs, and to focus on that in this way. Number one, I want to talk a little bit about some of the counts impersonating public officers. I want to talk about the forgery, the false statements, briefly, and talk about that, but also to raise this issue with the court. Now, we argued that in our pleadings, but the defendant still filed additional motions on these very issues and did a very, very good job in a lot of his arguments. We know that the court granted the stay for defendant Still because he's of the state legislature, and thus, had that not happened, Mr. Beaver would be here with me talking about these issues. I think that the Still pleading addressed a lot of the issues that were raised in the response by the state, and so with the forgiveness, hopefully, of my dear friend Mr. Beaver, I'm going to mention some of the things that they mentioned, but I would hope on behalf of defendants Still, the court may listen to what I say, but also prior to ruling on these particular issues might afford defendant Still the opportunity to have his own oral argument day so that he could more fully address these issues, and and I would appreciate that on his behalf. When we talk, let's get on to it. We're talking about impersonating a public officer charge, and we talk about that. When we talked about that, we talked about whether or not the
Definition of public officer, right?
Impersonating a public officer charge, count 8. We say that's subject to dismissal. In that pertinent part, it says on October the 14th, on or about December 2022, unlawfully, falsely held themselves out as the duly elected and qualified presidential electors from the state of Georgia, public officers with the intent to mislead. Now, what we did in our pleading is we said, well, that is defective because under the statute 2151, as public officer, there is no reference there to presidential electors as being public officers, and therefore that should carry the day for us. The state's response says, well, not so fast, Mr. Gillen. We've got cases here that talk about situations in which 2151 doesn't carry the day and isn't.
Well, not even cases. I mean, the statute itself.
Right.
I mean, you're pulling that from the ethics statute.
Exactly.
So I'm not really sure why I'd even look at that. I mean, public officers all throughout the code, and it's just kind of one of those hanging kind of question marks, I suppose.
So what the state does, and I can see the court's point. I'm not going to argue that. What I am going to say is that what they say, they cite cases where there are individuals that are impersonating agents, police officers, peace officers, or agents for Metro Atlanta Human Trafficking Task Force. Okay, that falls into that category. Trafficking in the task force or a federal agent. Those are things that the state responds to. I think that in the Still motion, it covers some of the concerns the court may have regarding this issue of public officer and why we think that we should prevail on this as well. Again, hoping Mr. Beaver has his day.
Well, do me the favor, actually, I've kind of put the Still motions in a box, and I haven't opened it yet, so make those arguments for me.
Well, I'm going to,
all right.
but not as articulately, I'm sure, as Tom could do it. But I'll give you the flavor. The flavor of it is that in the Still motion, which we adopted after it was filed, it talks about how other case law in Georgia, when it talks about, first of all, 1610-23 doesn't define public officer. So we start from that, so that we've got that out there. Not defining the public officer. Now, but the Still pleading does say that the issue of who is and is not a public officer is addressed in other contexts in Georgia law, usually in the quo merito proceedings where somebody's trying to find out the legitimacy of somebody having or holding a particular office. And in that context, there are cases citing in the Still pleading that address this very matter. They cite Brown v. Scott and as a case in which the Brown v. Scott case, whether or not an individual has designation or title given to him by law or exercises functions concerning the public assigned to him by the law, they cite Brown. That the inquiry doesn't really end there. The Georgia Supreme Court has noted the term public officer involves the idea of tenure, duration, fees, emoluments, and powers, as well as that of duty. And so that's McDuffie v. Ferguson, and that has to do really with grand jurors. So when someone says, well, is a grand juror a public officer? And the court, breaks down an analysis talking about that, saying not really, because grand jurors may only meet for a few days. They're not essentially, they're not there for some sort of duration or tenure. They don't take the same oath of office as prescribed for public officers, and they lack the element of tenure and duration which must exist to qualify as a public officer. Well,
so how would that apply again to like a purely fictional task force?
Well, I mean, let's forget the purely fictional task force. It would let's have it that case law from our Supreme Court, how it applies to our case, and how it applies to our case is the presidential electors are not people who have.
We are watching a Georgia courtroom where former President Trump's attorneys have been asking the judge to throw out the election interference charges against him in that state. I want to bring in ABC News executive editorial producer John Santucci and ABC News contributor, former Georgia prosecutor Chris Timmons for more. John, Trump's attorneys here say the charges should be dismissed because then President Trump was engaged in what they're calling political speech, and they say that, that's protected by the First Amendment, and so this all should be protected by the First Amendment. What do you make of the way they're laying out these arguments so far?
Well, listen, I think what their job right now is to say Donald Trump in his statements was doing it as a candidate for office and as, at the time, President of the United States, and was doing it because it was his First Amendment right to express his opinion. What they are trying to do is take the heat out of the language, right? Because it was so much of Donald Trump's words and rhetoric, both publicly stated, especially when he spoke on the morning of January 6th on the National Ellipse right outside the White House, and also the phone calls he made. It's Secretary of State in Georgia, Brad Raffensperger, to other elected officials, trying to pressure them to violate their oath of office. And what the Trump team is saying is that, look, this is political speech. He is allowed to make a statement and give an opinion about an election, especially one he was in. What the prosecutors have argued here is that he tried to get government officials to violate their oath of office and tried to get individuals to overthrow the government. And in the case of Georgia, it's those examples of getting people to go to where votes were being counted, that they followed Donald Trump's words and rhetoric, both what he was saying, and let's not forget, too, this was a time in life, yet once upon a time, that Donald Trump was on Twitter, right? And how many times did his supporters say, I believe what he's writing on Twitter? It's a directive to us, right? We're not backing down. I mean, I remember the images on the morning of January 6th of, people reading his tweets and saying, no, he doesn't really want us to back down. He wants us to keep going because that's what he wrote the night before. It's really interesting how Donald Trump's supporters really take his language and rhetoric to heart. And what the Trump team is saying here is that it was not the intention to do anything illegal. And that is exactly what we're getting in this courtroom today.
Chris, former President Trump also often communicates in ways that can be left to interpretation. There's always a little room there, or usually anyway. One of the things, for example, that they're debating in court is what his intention was when he told the Secretary of State of Georgia, Brad Raffensperger, to find the votes, right? You have the prosecution here saying that he was literally telling him to violate his oath of office and make up these votes fraudulently. And you have Trump's team saying, no, he just meant he thought that there were votes out there that still could be found lawfully, and that's all he was saying as a form of political speech. How difficult does that make this case when you have to try to take the words and then figure out the intent or try to prove the intent behind them?
Sure. So, Diane, there's two parts to this matter. The first is what's going on today, and that's the judge looking at the indictment and trying to decide if there is protected political speech here. And a lot of that comes down to intent. But I think that's a lot of the state's argument, Diane, is that, look, it's not you, the court, that's the one that's supposed to be making the determination on intent. That's why we have jurors. We're going to have jurors at the end of the day have got to make a decision on what that intent is. And to your point with regard to proof, the state's got a little bit of an uphill battle here in that they've got to prove that intent beyond a reasonable doubt. That's the standard that we all know here. And so they've got to prove that to a jury. So, yeah, proving intent is always difficult. There are a number of Georgia jury charges that talk about intent. You can infer it from somebody's action. You can infer it from other speech. And here, I think what they're predominantly relying upon is the idea that, Donald Trump was told by a number of different people that he had lost the election, that they needed to wrap it up, that they needed to, settle down. They needed to get out of office and make room for Joe Biden. But what happened in this particular case was that Trump didn't do that. Trump indicated that he was going to hang on to that office, and that's really what this Georgia case is about.
John, what are you hearing from Trump's inner circle about this case and how it's going so far?
Listen, they want this case to go away as quickly as possible. That's clearly not happening, so this is another delay tactic. What I am hearing is that they are turning their attention to the next trial, which Chris talked about earlier. Manhattan gets started in just a couple weeks, Diane.
All right, John Santucci, Chris Timmons, thank you both. And former king of crypto, Sam Bankman-Fried, is set to be sentenced today for masterminding a multi-billion-dollar fraud scheme. FTX founder Sam Bankman-Fried was convicted on fraud charges for using customer deposits to cover losses at his hedge fund. Prosecutors say he deserves as much as 50 years in prison. His lawyers have asked for a much lighter sentence of no more than 6 years. Senior investigative correspondent Aaron Katersky joins me now from outside that court in Manhattan for more. Aaron, I know you've been inside the court this morning. Talk us through what's happening right now.
Sam Bankman-Fried right now is standing at his place at the defense table in a beige prison smock and matching pants, his unruly hair prominent in the courtroom. He's looking down and occasionally mumbling, but he's addressing the court directly in his plea for leniency. Diane, he's telling the court, I made a series of bad decisions, and he is acknowledging that he has some responsibility. Not full responsibility, the way he was talking, but some. And he says it haunts him every day, the collapse of FTX and its partner hedge fund Alameda Research. His attorney, Mark Mukasey, spoke before Bankman-Fried, telling the court that the sentence should be imposed with an open mind and a compassionate heart. Mukasey told the judge, I'm asking the court not to destroy the prime of this complicated young man's life. And that's the defense argument, Diane, that Sam Bankman-Fried is not the greedy monster the way prosecutors may portray him, but his attorney called him a math nerd who does sometimes struggle to communicate his emotions or communicate what he's thinking and feeling, but he is not somebody like Bernie Madoff, who the defense called a cold-blooded financial assassin.
Now, Aaron, the Justice Department is cracking down on crypto scams. Could they be trying to make an example out of Sam Bankman-Fried?
I think there's no question. And in fact, prosecutors have pointed to what they call Bankman-Fried's greed and hubris. They say for years he was gambling with other people's money, and he needed to be sentenced for quite a long time. Otherwise, if he gets out too soon, they say, he could commit another fraud. And the defense really takes issue with this notion of deterrence, but it's clear, Diane, prosecutors want to send a message to other crypto criminals with the way this sentence is imposed.
Senior investigative correspondent Aaron Katersky, thank you. A new video has been released of the moments before a cargo ship hit a Baltimore bridge. The Coast Guard says crews and barges are on their way to remove wreckage from the Francis Scott Key Bridge collapse. The Department of Homeland Security says this could be the costliest shipping accident in history. ABC's Ike Ajachi joins me now from near that collapse site. Ike, officials say the priority now is safely removing this bridge and the ship so that the port can be reopened. How's that going, and how long do they think that's going to take?
Well, Diane, the focus of the next 24 to 48 hours will be a salvage and removal operation, essentially getting the dolly out of what used to be the middle of the Francis Scott Key Bridge, out of the Patapsco River, and out of the Port of Baltimore. Take a look right now. You can still see that massive container ship off in the distance. The focus of this entire mission since the onset of this incident, you can still see all those containers packed up high, and most notably, portions of the Francis Scott Key Bridge still located on the bow of the ship. Now, here's what's focusing today on Thursday right now. Dive operations. Divers are essentially in the water right now, assessing the stability and the structural integrity of the ship. They're also going to be underneath the water, trying to make sure there's no more of that mangled metal, that twisted metal that could prevent the dolly from being tugged out of the Patapsco River and eventually out of the Port of Baltimore. Now, once that assessment is done, crews will definitely, at that point, walk onto the ship and begin removing those 13 damaged containers out of the ship, and eventually, ultimately leading up to removing portions of the Francis Scott Key Bridge from the bow, preparing the ship to be tugged out of the Patapsco River and away from the Port of Baltimore, Diane.
Like, the NTSB is talking to members of the crew who've been on that ship since the crash, and they're trying to get to the bottom of what caused the power outage. Anything new on that front?
Well, here's what we know. 23 members were on the dolly at the time of the collision. 2 local pilots and 21 permanent members. We're being told right now that they are still on the ship, a ship that currently has power, and they are, in fact, cooperating with investigators. But here's what we know right now. There's still preliminary facts actually point to a power outage that could have caused this massive ship to slam into the bridge, but that's obviously still under investigation. This is going to take a significant amount of time. Right now, we're being told that the preliminary report about this entire incident could take about 12 to 24 months for it to be released, Diane.
Meanwhile, Ike, 2 bodies were recovered from the river. 4 workers are still unaccounted for. What else do we know about the victims?
That's right. We're starting to learn more information about those members that have been unaccounted for. We know yesterday those 2 individuals were found in that red pickup truck submerged 25 feet below the surface of the Patapsco River. And police are starting to release the identities of those individuals. The first one, 35-year-old Alejandro Hernandez Fuentes, a native of Mexico who lived in Baltimore. And the second individual, 26-year-old Dorlian Roniel Castillo Cabrera, a native of Guatemala who lived in Dundalk. Officials tell us that they've been identified, one of those individuals, by his driver's license that was still located in his pocket, and the second individual is located by a fingerprint. Now, we, of course, know the remaining 4 construction workers are still presumed dead, obviously still the focus of this recovery mission. Right now, we're still being told that right now, today, everybody, the focus right now is getting this ship out of the Port of Baltimore and trying to have operations resumed at the moment, Diane.
Ike Ajachi in Maryland, thank you. The Israeli raid on Gaza's largest hospital, Al-Shifa, is now in its 10th day. Israel claims it's killed about 200 Hamas fighters and detained hundreds more since the siege started. This comes as UNICEF says more than 200 schools have been directly hit by Israeli strikes since the war began. The organization says at least 53 schools are destroyed. Foreign correspondent Britt Clennett joins me now from Jerusalem with more on this. Britt, what's it like in Gaza right now?
And hell on earth is the way that aid agencies are describing it to me. We're talking about a lack of food. The UN saying a famine is imminent, especially in the northern areas. Apparently in Rafah, the food situation is a little bit better. If you have tins of food, you're considered quite rich and quite lucky. People, they say, are eating like cats. I was speaking to a family here in Jerusalem. They're in hospital being treated. They're from Gaza. And this little girl, she's 12 years old, she has a tumor, and she grabbed me and hugged me, and she cried and cried and cried because she was saying, my sister is still in Gaza and I worry about her every day. Now, this sister this little girl is terminally ill, and on top of her health concerns, she's worrying about her family back in Gaza, and she's saying, please, I don't want to go back there despite my family being there. My home is destroyed. So on top of this, you're starting to see the mental health crisis build, people on the streets begging for food, begging for clean drinking water. I was speaking to someone a bit earlier who said that getting a cucumber is something I can only dream of, Diane.
Now, Britt, I know you spoke to the spokesperson for UNICEF about the humanitarian crisis in Gaza. What did he tell you?
Yeah, James Elder of UNICEF really sounding the alarm. I was speaking to him from Rafah. Let's take a listen to what he had to say, having spoken to people on the ground in Gaza and visiting the hospitals there.
When you are in Gaza, Britt, and at 3 in the morning, or now, 10 minutes ago, with horrendous bombardments, but at night time, you lie in bed and you just hear and your building shakes and it feels like you're lying in a coffin. You just don't know what's going to happen, if you're going to get hit. This has been the reality for 5+ months for children.
James, what does that do to a child's mind, to their trauma?
I don't think it's an exaggeration to say that every child here now will require some sort of mental health support. And you talk to adolescent girls and some of them say, I want to die. I want this to be over.
Just incredibly powerful and devastating from James Elder of UNICEF there. Adolescents wanting to die, children saying they're lying in coffins. I mean, the picture is just building, it's bleak, and aid agencies, as I say, are really trying to sound the alarm, saying that aid needs to get in and the world needs to pay attention.
Now, Britt, Israeli sources tell ABC News another aid ship is expected to arrive in Gaza. What's the latest on that, and how much of a difference could this realistically make at this point?
Well, I think that's a really good question, Diane. It's a drop in the ocean. That's what I'm being told. Before the war, we're looking at something like 500 trucks. Now it's more like 90 to 150. So really, what is trickling in isn't doing enough. There is a long line of lorries fully loaded with aid supplies desperately needed in the Gaza Strip. It's backing up on the Egyptian side of the border with Rafah. Now, they can only enter Gaza through Israel after a complex and quite bureaucratic series of checks. Now, the absence of this kind of adequate supply of aid, it's forced other countries, including the US, to drop aid in, and that has had problems in itself, people dying, scrambling to reach that aid.
All right, Britt Clennett in Jerusalem, thank you. Coming up, former President Trump's takeover of the RNC is complete, with his daughter-in-law, Lara Trump, now in charge, while potential employees are being asked about the 2020 election.
Whenever news breaks,
we are here in Israel, a nation at war after that brutal surprise attack by Hamas.
On the ground in Ukraine, reporting from Lewiston, Maine.
The scene of a horrific mass shooting.
ABC News Live is right there everywhere.
From the scene of that deadly missile strike in Dnipro, Ukraine.
Reporting from the earthquake in Turkey.
In rolling forth, this tornado tore through this little town.
From the most devastating disaster in Hawaii.
From Charleston, South Carolina, on the 2024 campaign trail.
In Iceland. Let's go.
Traveling
with the president in Mexico City.
Wherever the story.
From the front lines, from southern Israel,
outside the Gaza Strip,
in Beirut,
From the FBI.
Reporting from the nurses on the picket line.
Here at 10 Downing Street in London.
Streaming live to you.
Wherever the story is.
wherever the story is.
Wherever the story is, we're going to take you there.
you're streaming ABC News Live.
ABC News Live.
You're streaming ABC News Live.
ABC News Live, streaming free everywhere. America's #1 streaming news.
I have a point of contact.
They're expecting us?
This is our secret world we have.
Do you think we're going to be safe?
I don't know.
This is my pen. Inside that pen is a slice of human brain.
These are assassinations, and people are going to be murdered.
There's really no telling what some of them will do.
Oh my God, look.
It's happening everywhere and anywhere.
Wow.
Beyonce's conquering country.
My family loves Beyonce.
Cowboy Carter comes into the world at a very complex time. People are saying this song is too good to resist.
Just because you sing hip-hop music with a country accent does not make it country music.
The stay in your lane, well, that's not real country. It takes somebody who is at superstar status to do something that shakes it all up.
It's Beyonce country. This is Impact by Nightline, now streaming on Hulu.
There's a lot going on.
Yet another avalanche warning that's up.
To catch you up with what happened overnight. A dangerous ice storm is impacting the morning commute.
What's happening today? Escalating tensions in the Middle East.
What people are talking about, the migrant crisis.
Fast, straightforward.
With some fun in between.
How does billionaire sound?
Sounds good to me. The moose started chasing a dog.
First thing in the morning.
America This Morning.
America's #1 early morning news.
On ABC News Live.
Welcome back. Former President Trump's daughter-in-law says the Republican National Committee won't pay Trump's legal bills. Lara Trump was recently elected co-chair of the RNC, and her leadership is already raising some questions about the committee's role in this election cycle. ABC News has learned the RNC is now asking anyone who wants to work for them if they believe that the 2020 election was stolen. The RNC said in a statement, quote, "We want experienced staff with meaningful views on how elections are won and lost." ABC News political director Rick Klein joins me now for more. Rick, Lara Trump insists Republicans are moving past 2020 in that election, but Trump has repeated these false claims about the election being stolen on the campaign trail. So how significant is it that the RNC is now giving applicants what appears to be a litmus test on this issue?
Yeah, and Diane, we should be clear. We don't know that answering that one way or the other means you can or can't be hired by the RNC. We know they've hired at least one attorney who has fought against the legitimacy of the last election, and at least another prominent attorney who said that it's over and done and that Republicans should move on. I think the problem with Lara Trump saying that the Republican Party is only looking forward is that, yeah, the candidate at the top, who happens to be her father-in-law, is not beyond it, and he continues to spread lies and misinformation about the results of the last election. I think the question about how they staff up and whether it's a litmus test is a real and relevant one, because this is a party that is now been built to support Donald Trump's candidacy, full stop. They really reorganized themselves, reoriented themselves to focus on the presidential race. And as long as the former president is focused on 2020, you can imagine that a lot of people working at the RNC will also have that same focus.
Meanwhile, President Biden is attending a campaign fundraiser in New York with former Presidents Obama and Clinton today. What are you watching for there? And what role could those former presidents play in Biden's campaign moving forward?
We'll start with money. They're talking about a whopping $25 million raised off of this one event alone. It is an extraordinary event, very unusual to have three presidents in the same room at the same time. They've used it for grassroots fundraising as well as very high dollar fundraising, and a lot of people will be watching via live streams to see portions of it as well. I think on the trail, I don't expect we're going to see a lot of Bill Clinton, although there's still pockets of the party where he's very popular. But Barack Obama remains a very popular figure and someone that I think Biden will want to have out there as much as possible. I look for both he and Michelle Obama to be relatively active. They've let it be known that they'll do what they can to support Joe Biden, the man that he served under for 8 years as vice president. So I'd imagine that there'll be more to come, although, of course, there's limits to what any surrogate can do. So we'll see if they do more events like this, but it is quite a scene that we're expecting today at Radio City Music Hall.
Meanwhile, Rick, I need to talk about former Senator and Vice Presidential candidate Joe Lieberman. Tributes are pouring in after he died yesterday at 82. And Lieberman co-founded the No Labels group. He was trying to run this third-party ticket to take on both Trump and Biden. Former New Jersey Governor Chris Christie announced last night that he would not run as their nominee. So where does that leave this third-party movement, and how could that affect the election cycle?
Yeah, right now, No Labels does not have a candidate, and they've struck out on all of the major efforts that they engaged in. Chris Christie was the latest in a long list of people, including Joe Manchin and Larry Hogan, Jeff Duncan, the former lieutenant governor of Georgia, Chris Sununu. All these people have said thanks, but no thanks for your interest. I do think it's TBD whether it's impactful this cycle or not, but I think what Lieberman made his final political project is something that's brewing in America. There are a lot of people that are upset about the two-party system. They don't like either the Democratic or the Republican nominees that are all but inevitable this year. And Lieberman, who was a Democrat, who then supported the Republican for president, ultimately was an independent, I think was onto a powerful notion. Whether No Labels is the vehicle for it or not, right now it looks like not for 2024. Third-party candidates might be an impact. It won't be No Labels. But Lieberman, I think, is planted some seeds that we could see the results of for some time in again, what ended up being his final political act.
All right, ABC News political director Rick Klein. Rick, thank you.
Thanks.
We'll be right back.
Tonight, the ripple effect of the bridge collapse in Baltimore. Plus, as Israel and Hamas reject a Gaza ceasefire, will U.S. aid arrive before people starve? More Americans turn to World News Tonight with David Muir, the most watched newscast on television.
Monday, April 8th, all eyes to the sky for a total solar eclipse, a breathtaking celestial event. Eclipse across America. Streaming on ABC News Live, National Geographic Channel, Nat Geo Wild, Disney Plus, Hulu, and live on ABC.
Everything is so fine, little bit of sunshine. Some more, just a little bit. Breathe more, just a little bit. Smile a little more, and I'm into it. I've been running through the strange life. Pictures on my phone, like everything is so fine, little bit of sunshine.
Good morning, America.
Real Housewives of Beverly Hills star Erica Jane.
Celebrity attorney Tom Girardi.
This story was a nuclear explosion.
Today, several victims will get a chance to finally meet Erica Girardi.
I'm at sort of a loss for what to say.
Did you see the documentary?
The Housewife and the Hustler? I did.
I wanted Erica to say, I'm sorry, face to face.
Erica, why did it take you so long?
The Housewife and the Hustler 2, only on Hulu.
Why do so many people start their day here?
From ABC News, this is Start Here.
To be in the know and get a different take on the day's top stories.
A lot of news today, so let's get into it.
Listen now to the Daily News Podcast honored with 4 Edward R. Murrow Awards and see why the New York Times calls it a news podcast worth listening to. Start Here, ABC News. Make it your daily first listen.
Now, that's a part of the story I bet you didn't see coming.
Wherever you get your podcasts, start here.
Reporting from the nuclear-armed ballistic missile submarine, the USS Kentucky in South Korea, I'm Martha Raddatz. You're streaming ABC News Live.
Welcome back to ABC News Live. First, we're following breaking news out of Georgia, where attorneys for former President Trump and his co-defendants are asking for charges to be dismissed in the election interference case against them in the state. Let's listen.
They did not have the authority. It's not whether some GBI agent thinks that he can come in here and tell the jury, pay no attention to federal law, pay no attention to the dissenting opinion in Bush v. Gore. Pay no attention to that. I'm a GBI agent. I say we can do it. That's wrong. They lose there because the law is very, very, very clear. And we can go back and we'll both the state and I know the Schaefer team will go back to look at our argument that we made to the court. When my recollection could be wrong, I don't think so. We'll see. But my recollection was because the pleading was a part of the court system that we had a citation which permitted the court to take that into consideration as part of the record and thus not going outside of the record for speaking to Muir. I could be wrong. but we'll get that to you quickly, because that. And they latch onto that to say, pay no attention to the reality of what happened in this courthouse, in the court filings, which destroys their argument. And so, with that, Your Honor, I'll sit down, and then I'll go back and get my other folder.
So, on your last motion here, kind of as we were with the First Amendment issue, I think we need to figure out where we are procedurally. Federally, it sounds like, this would be a pretty common motion. It'd be a surplusage motion. Georgia, it's not quite as clear for us. So, excuse me. Let's start with just the authority to kind of take a scalpel to an indictment and cut out things we don't like.
Well, I mean, Your Honor, we talk about, there are two components to this motion. One, there's the strike surplusage, and then there's a dismissal that we asked for, which is kind of also a component of the other. Now, we cite the State v. Corin on the issue of being able to, the allegation, the indictment is not wholly unnecessary to constitute an offense as mere surplusage. We think,
right. But when we read the surplusage opinions, we're talking about, a miscited code section or a wrong date or something like that. So I don't know. I don't think that's what you're characterizing.
No. I guess this is where I'm.
It's more just a legal conclusion, right?
Let me. A legal conclusion, number one, but it's even more than that. It's this. When they continually, in their pleadings, in the indictment, in their pleadings, in their extrajudicial comments that they make, they have bombarded the defendants, the electors in this case, with the concept of and the phrase of fake electors. Now that is not, that is a description, a conclusion, and a pejorative description.
So it's a legal conclusion you very much disagree with. It's the core of your defense.
I think it's not only a legal conclusion, but it's also something that should be stricken because it is just a pejorative statement. I'm not saying. I'm saying. I can call you something really nasty in an indictment, and it doesn't necessarily have to be a legal conclusion about your violation of a particular law. And so that's what we have here. And we have this permeating this case.
Well, I'm just trying to, again, based on what we've seen and is allowable in Georgia, let's just make it simpler. If in a murder indictment someone's alleged to have acted with malice aforethought, that's a legal conclusion.
Well, that's right.
And it's something that the defendant may really have an issue with. But we don't strike it. We just go forward and we go to trial.
Different world, different cases, not the point that I'm trying to make. What I'm trying to make is, and you put in malice aforethought because you put that in there to define the terms.
Sure. What about this one? There's one I remember when we talk about nicknames and aliases. And I remember there's one in Georgia from the 90s. They put in an alias of Stomper. And he had beat the defendant to death.
Well,
and the Supreme Court said, that's okay.
You know why? Because they probably proved that there was an alias of that guy called Stomper. That's different than that
trial. The state's saying we're going to prove that you're unlawful elector.
Well, no. In this indictment, what they have done in the indictment, it's not necessary if they want to. And we think it should be stricken. We think the count should be dismissed. We know that based upon the case law that we've cited. But in closing arguments, Lord forbid we ever get to closing arguments, hope we don't. But if we did, and they stood up and they said, well, we think that they were that we think the evidence shows that they were fake electors. That's one thing. That's argument. That's advocacy. There's no place for it in the indictment, and there's no place for it in what they have done, not only in the indictment, but in their pleadings and statements they've made outside to the media. What they have tried to do is they want to have ingrained in the minds of the community and of jurors a concept that if you were not a Democratic elector on December the 14th, casting your vote at some other part of the state capitol, then you are a fake elector, and that is a pejorative term, not necessary for the charges, and should be stricken. That's the point that we're trying to make. And as it relates to our other arguments concerning the dismissal of those counts, I don't think I need to go back over. Most of my argument, or our argument on that, really deals with the Electoral Count Act, so I don't think I need to revisit that in case the court
we'll get there.
really wants to hear that again. I don't think you do. But absent that, Your Honor, we think, number one, that the count should be dismissed for the reasons articulated earlier and in our pleading, and number two, that even if the counts are dismissed, in addition to that, references throughout the indictment to fake electors should be stricken as well. Thank you, Your Honor.
All right, thank you, Mr. Yellen.
Judge, I'll be brief. Nowhere in this indictment is the phrase fake elector. It does not exist. Literally not in the indictment. So I'm not really sure what we're talking about, removing something from the indictment that's not there. As the court pointed out, and I struggle with this motion, and I'm not going to say much because we're primarily relying on our response, but an indictment is itself a legal conclusion. Every allegation in an indictment is a legal conclusion. That's what an allegation is. And so if indictments aren't allowed to have legal conclusions, then I guess we aren't allowed to have indictments anymore. Judge, I think what the defense's strategy is here, and I know it's their strategy because they asked for it in the motion. They say, Judge, you should strike this language from these counts because we don't like it, it's not fair, it's pejorative, whatever reason. And now that you've stricken it, the counts don't charge a crime anymore, so you should dismiss them because they don't charge a crime anymore. That's nonsensical. We cite in our briefs opinions where the appellate court said you literally can't do that. If something's essential to the charge, if it's essential to pleading an essential element of the charge, you can't strike it. It's not subject to being stricken. And I just highlight one citation that we reference in our brief, Malloy versus the state, 293 Georgia 350 2013 Supreme Court case. And that case says that when language in an indictment accurately describes the offenses charged and makes them easier to understand or more easily understood, they're not subject to being stricken because they're not surplusage. And that in making that in analyzing language in an indictment, in this context, Malloy also says that the language is to be interpreted liberally in favor of the state. And so with that, again, we rely on our pleadings. The phrase fake elector does not exist in this indictment. Take any questions that the court may have, but otherwise, nothing further.
Maybe one. I've seen a line of cases talking about whether defects, can be stricken, and a lot of that depended on whether they're material or non-material. Is it safe to say that these phrases, the ones that are highlighted here, lawful elector votes, false electoral college votes, and duly elected and qualified presidential electors, would you say those are material phrases for each of the charges they appear in?
So I think that's a great question, and I think there's kind of a superficial answer and then maybe a more in-depth answer. My superficial answer is yes, they're material in the sense that they make the charges more easily understood. They're accurate to describe the charges. I am familiar with that line of cases, and it's a little bit unclear in the cases whether material means that or whether material means that, if you strike something from the indictment that the count falls apart. So I'm not clear. What I know is in this context, I don't think it matters because what's being challenged, I think that it's approved of by our appellate decision.
If you've happened to go down that road, though, and we take the position that material means it can still survive General Demur, any thoughts there?
Judge, again, turning back to Malloy, the holding in Malloy is that as long as the language in an indictment, even if it's not essential to an essential element, as long as it's accurate, it describes the offenses charged, and it makes it more easy to understand, it's simply not surplusage. If it's not surplusage, it's not subject to being stricken.
But do we think these phrases are material and meaning they're necessary to survive a general demur? I don't have them in front of me. So.
I don't either, and so I hesitate to give an answer without the indictment in front of me.
That's fine.
You know, again, as long as the charges track the statute, they survive a general demur. So anything that's not statutory language, I guess, wouldn't fall into that category. But then we get into special demur territory, and that's a whole different situation.
All right. Fair enough.
Thank you, Judge.
Okay. Thank you all. Anything else we should, or matters of housekeeping, anything else we need to take up before we break? Anything from the state?
Nothing from the state, Your Honor.
All right. Thank you, Ms. Young. Anything from either counsel? Okay. And we'll be adjourned. Thank you.
Court is adjourned there in Georgia, where former President Trump's attorneys have been asking the judge to throw out the election interference charges against him in that state. They're arguing on the basis of First Amendment here. I want to bring in ABC News executive editorial producer John Santucci, along with ABC News contributor, former Georgia prosecutor Chris Timmons, for more. John, one of Trump's co-defendants here is also seeking to dismiss the charges against him. The former Georgia Republican Party chair, Dave Schaefer, is arguing his attorneys were attempting to comply with advice of counsel when he served as a so-called fake elector. What do you make of all this intertwining right now?
You know, the reality is that they are all grasping at straws and way to make this case go away, right? So just to bring everybody back up to speed, right? This whole fake elector plot, if you will, was an effort by Donald Trump's campaign and other Trump loyalists to build an alternate slate of electors, the people that certify the elections for every state, because Joe Biden was declared the winner of the elections in the state of Georgia. That was the team of electors that was certified by the state legislature and was then going to deliver those results to Congress, which is the typical process before the votes are certified on January the 6th, which happens every 4 years. In this case, what David Schaefer and others did as part of a directive from Team Trump was to build out an alternate slate, because they maintained that the election was rigged, to use their words, and that the votes were compromised, and thus, in their opinion, more research needed to be dug in to the tabulation of votes, as Sidney Powell and others have already testified about, and thus an alternate slate of electors should be built, which Schaefer and others were a part of. And of course, what they're leaning into is they took advice of counsel and others, because remember, Rudy Giuliani very publicly was the face of Team Trump, going down to the Georgia state legislature, meeting with officials, forcing them, if you will, to violate their oath of office and say, take the Joe Biden electors, put them aside, go with this alternate slate of electors that says Donald Trump won. Now, obviously, that did not happen, but regardless, that is why we're here, right? It's the efforts by Donald Trump and his allies to overturn the results of the election, and that is what David Schaefer, Trump in this motion are trying to do. But this is just one of many, right? We have seen how many motions so far with the same goal: make this case go away.
Chris, prosecutors say the phrase fake elector doesn't even exist in the indictment. So how significant is that in the context of this argument?
Yeah, I mean, I think it's more sort of egg on your face type thing than it is significant legally. I mean, you know, if you're up there complaining about the term fake elector being in the indictment and it's not there, that's kind of embarrassing for the defense side. But really what they're getting at is there are a lot of other terms in there that talk about, you know, duly elected electors, things of that nature. What they're saying is that those were, what we heard at the end there anyway, was that those are legal conclusions and that they don't belong in an indictment because they're, you know, you shouldn't have legal conclusions in there. They should be all about the facts. That said, though, the state's absolutely right. I mean, almost every indictment has, you know, legal conclusions all over it. For example, the example they gave is malice aforethought, kind of what we hear about in a murder indictment. Sort of that's along the lines of premeditated and deliberated before the murder occurred. And so, you know, there's always going to be legal phrases that are in indictment. The fact that the defendant doesn't like those legal phrases is not a reason to have them taken out, Diane.
John, earlier Trump's attorneys argued the entire indictment is based on political speech, and so that should all be protected under the First Amendment. The prosecutors are saying this speech was part of a pattern of criminal conduct. So what's at stake at this stage here?
Well, and what's at stake is clearly what the heck is going to happen with this trial, right? Because at the moment, we don't have a date. We have a proposed date from the DA for sometime in August. The thing that I keep coming back to is that if you look at when this case was originally charged, which was ironically almost a year ago with August, the DA said in one of their initial presentations the case would take 4 to 5 months to present. Okay, so let's put that on the table first. The other thing that we obviously have to go through is jury selection. Think about the other case right now that has gone on in Georgia recently that was a RICO indictment. It involved the YSL gang. That took nearly 8 months to seat a jury. Now, that was 35 defendants or so. This is, 18, a little less now. I think we're down to 15, including Trump. But do they charge them all together? Do they do 2 separate trials? There's so many questions to work out. But again, let's just back up. If the presentation of the case is going to take several months and you're going to start in August, does that mean that we're going to be seeing this trial play out while voters are heading into the polls? It would certainly seem that way. And the argument from Team Trump is that, hey, listen, that is election interference. That's going to be the question the judges weigh in on next.
Chris, how do you get around that, the timing here and the complications that will come with seating a jury over a case involving the former president?
Well, so Diane, I mean, the argument we hear from every defendant is this is inconvenient for me in some ways. And I understand that, this is obviously a case of national importance, and so is the election. But, just because somebody's a doctor and they've got surgery scheduled, or, they've got a lawyer and they've got an important meeting scheduled, doesn't mean that, trial's going to stop for that type of thing. It's not like the federal government where, the Department of Justice has a policy that they won't bring somebody to trial, or actually they won't indict somebody within 90 days of an election. Here, I think we heard recently in some of the other federal cases that they're not abiding by that kind of rule as it comes to trying cases. But yeah, there's an entirely likelihood or possibility here that the former president could be sitting in a Georgia courtroom on the day that voters are deciding whether to elect him the next president of the United States.
John, what are you watching for next?
Well, I'm waiting to see a couple things. I think, one, I really want to see what's going to happen with the trial date here. 2, I do think what's going to be interesting is that, Trump has not been able to go to any of these proceedings so far. He thought of going to this one today. He's instead attending the funeral for the NYPD officer who was tragically killed earlier this week on Long Island later this afternoon. But what I'm actually curious to see is that when we have this first criminal trial start later in April in New York, that's going to go anywhere from 6 to 8 weeks, what happens with the other cases, right? Because in theory, they're criminal cases. Trump has the right to attend. Do motions get slowed down because of that? Does process get slowed down because of that? I don't think we've ever really seen any of this, obviously, right? You've never seen a former president, any president on trial, but that collision course, right? It's not just this one case. There's 3 other criminal cases. I'm curious that when that case gets to trial and we're fully in it, what happens to the other 3? Do we move forward at all?
All right, John Santucci, Chris Timmons, thank you both.
Thank you.
We'll be right back.
Whenever, wherever news breaks, it's so important to always remember that lives are changed. Here in London, in Buffalo, Uvalde, Texas, Edinburgh, Scotland. Reporting from Rolling Fork, Mississippi. Ukrainian refugees here in Warsaw. We're heading to a small community outside of Mexico City. Getting you behind the stories as they happen. ABC News Live Prime. We'll take you there.
Stream ABC News Live weeknights wherever you stream your news. Only on ABC News Live.
Tonight, the ripple effect of the bridge collapse in Baltimore. Plus, as Israel and Hamas reject a Gaza ceasefire, will U.S. aid arrive before people starve? More Americans turn to World News Tonight with David Muir, the most watched newscast on television.
I have a point of contact.
They're expecting us?
This is our secret world we have.
Do you think we're going to be safe?
I don't know.
This is my pen. Inside that pen is a slice of human brain.
These are assassinations, that people are going to be murdered.
Definitely.
There's really no telling what some of them will do.
It's happening everywhere and anywhere.
Wow.
Beyonce's conquering country.
My family loves Beyonce.
Cowboy Carter comes into the world at a very complex time. People are saying this song is too good to resist.
Just because you sing hip-hop music with a country accent does not make it country music.
The stay in your lane, well, that's not real country. It takes somebody who is at superstar status to do something that shakes it all up.
It's Beyonce country. This is Impact by Nightline, now streaming on Hulu. What are the questions every couple should ask and answer before jumping into marriage, owning a home, and having children? Next week on GMA, oh yeah, we're going there. Before you take the lead. Next week on Good Morning America.
Babe Ruth, Hank Aaron, Shohei Ohtani, legends of the game. But now the list of greats redefined. From ABC News, Reclaim the Forgotten League, a side of the story of baseball you have never heard before like this. The award-winning podcast is back. Listen wherever you get your podcasts or scan the QR codes you see here.
You're watching America's #1 streaming news, ABC News Live. Breaking news, exclusives, live reporting across the globe. Keep streaming with ABC News Live.
Welcome back. Former President Trump's daughter-in-law says the Republican National Committee won't pay Trump's legal bills. Lara Trump was recently elected co-chair of the RNC, and her leadership is already raising some questions about the committee's role in this election cycle. ABC News has learned the RNC is now asking anyone who wants to work for them if they believe that the 2020 election was stolen. The RNC said in a statement, quote, "We want experienced staff with meaningful views on how elections are won and lost." ABC News political director Rick Klein joins me now for more. Rick, Lara Trump insists Republicans are moving past 2020 in that election, but Trump has repeated these false claims about the election being stolen on the campaign trail. So how significant is it that the RNC is now giving applicants what appears to be a litmus test on this issue?
Yeah, and Diane, we should be clear. We don't know that answering that one way or the other means you can or can't be hired by the RNC. We know they've hired at least one attorney who has fought against the legitimacy of the last election, and at least another prominent attorney who said that it's over and done and that Republicans should move on. I think the problem with Lara Trump saying that the Republican Party is only looking forward is that, yeah, the candidate at the top, who happens to be her father-in-law, is not beyond it, and he continues to spread lies and misinformation about the results of the last election. I think the question about how they staff up and whether it's a litmus test is a real and relevant one, because this is a party that is now been built to support Donald Trump's candidacy, full stop. They're really reorganized themselves, reoriented themselves to focus on the presidential race. And as long as the former president is focused on 2020, you can imagine that a lot of people working at the RNC will also have that same focus.
Meanwhile, President Biden is attending a campaign fundraiser in New York with former Presidents Obama and Clinton today. What are you watching for there? And what role could those former presidents play in Biden's campaign moving forward?
We'll start with money. They're talking about a whopping $25 million raised off of this one event alone. It is an extraordinary event, very unusual to have three presidents in the same room at the same time. They've used it for grassroots fundraising as well as very high dollar fundraising, and a lot of people will be watching via live streams to see portions of it as well. I think on the trail, I don't expect we're going to see a lot of Bill Clinton, although there's still pockets of the party where he's very popular. But Barack Obama remains a very popular figure and someone that I think Biden will want to have out there as much as possible. I look for both he and Michelle Obama to be relatively active. They've let it be known that they'll do what they can to support Joe Biden, the man that he served under for 8 years as vice president. So I'd imagine that there'll be more to come, although, of course, there's limits to what any surrogate can do. So we'll see if they do more events like this, but it is quite a scene that we're expecting today at Radio City Music Hall.
Meanwhile, Rick, I need to talk about former Senator and Vice Presidential candidate Joe Lieberman. Tributes are pouring in after he died yesterday at 82. And Lieberman co-founded the No Labels group. He was trying to run this third-party ticket to take on both Trump and Biden. Former New Jersey Governor Chris Christie announced last night that he would not run as their nominee. So where does that leave this third-party movement, and how could that affect the election cycle?
Yeah, right now, No Labels does not have a candidate, and they've struck out on all of the major efforts that they engaged in. Chris Christie was the latest in a long list of people, including Joe Manchin and Larry Hogan, Jeff Duncan, the former lieutenant governor of Georgia, Chris Sununu. All these people have said thanks, but no thanks for your interest. I do think it's TBD whether it's impactful this cycle or not, but I think what Lieberman made his final political project is something that's brewing in America. There are a lot of people that are upset about the two-party system. They don't like either the Democratic or the Republican nominees that are all but inevitable this year. And Lieberman, who was a Democrat, who then supported the Republican for president, ultimately was an independent, I think was onto a powerful notion, whether No Labels is the vehicle for it or not. Right now, it looks like not for 2024. Third-party candidates might be an impact. It won't be No Labels. But Lieberman, I think, is planted some seeds that we could see the results of for some time in, again, what ended up being his final political act.
All right, ABC News political director Rick Klein. Rick, thank you.
Thanks.
We'll be right back.
Real Housewives of Beverly Hills star Erica Jane.
Celebrity attorney Tom Girardi.
This story was a nuclear explosion.
Today, several victims will get a chance to finally meet Erica Girardi.
I'm at sort of a loss for what to say.
Did you see the documentary?
The Housewife and the Hustler? I did.
I wanted Erica to say, I'm sorry, face to face.
Erica, why did it take you so long?
The Housewife and the Hustler 2, only on Hulu.
This is ABC News Live.
The crush of families here in Poland.
At refugee centers.
In Putin's Russia.
On the ground in Ukraine.
Close to the front line.
From the capital.
Destructive Cat 4 storm.
You're along I-5.
Boston is in the bullseye.
Let's go.
ABC News Live, America's #1 streaming news. Anytime, anywhere. Streaming 24/7, straight to you for free.
Thank you for making ABC News Live America's #1 streaming news.
What does it take to be the most watched newscast in America?
We are part of an operation.
Is this our combat operations center?
We're approaching the gate. Militants came in from different directions. Nuclear reactor. So you have a couple loaded and ready to go. The house is destroyed, but the flag.
Not a carry in it.
How important it made the USA. Great work.
Hi, appreciate you.
Thank you.
Ismail? David.
I'm David Muir.
I know who you are.
You
Watch
do?
you every night.
ABC's World News Tonight with David Muir is America's most watched newscast.
First thing in the morning.
There's a lot going on.
Yet another avalanche warning that's up.
To catch you up with what happened overnight.
A dangerous ice storm is impacting the morning commute.
What's happening today? Escalating tensions in the Middle East.
What people are talking about. The migrant crisis.
Fast, straightforward.
With some fun in between.
How does billionaire sound?
Sounds good to me. The moose started chasing a dog.
First thing in the morning.
America This Morning.
America's #1 early morning news.
On ABC News Live.
Why do so many people start their day here?
From ABC News, this is Start Here.
To be in the know and get a different take on the day's top stories.
A lot of news today, so let's get into it.
Listen now to the Daily News Podcast honored with 4 Edward R. Murrow Awards and see why the New York Times calls it a news podcast worth listening to. Start Here, ABC News. Make it your daily first listen.
Now, that's a part of the story I bet you didn't see coming.
Wherever you get your podcasts, Start Here.
Traveling with the president in London, I'm Elizabeth Folsey. Wherever the story is, we'll take you there. You're streaming ABC News Live.
Welcome back. March Madness is heating up with the Sweet 16 tipping off in the men's tournament tonight. Meanwhile, Iowa superstar Caitlin Clark has a decision to make about her future. ABC's Trevor Ault has the latest.
Hey there, so this is now a very top-heavy tournament. All the 1 seeds and the 2 seeds still in it. Of course, though, a lot of people want to find that potential Cinderella story. There's basically one left. 11-seed North Carolina State. They're taking on Marquette. And the Wolfpack have a power forward named DJ Burns Jr. He's a force. 6'9", about 275 pounds. And while a lot of other players are counting on NIL deals, he has his own side hustle. He actually owns 2 vending machines. Says he doesn't eat the snacks, though. He's too busy dispensing buckets. Tonight, we have superstitious coach Dan Hurley, his defending champs, the UConn Huskies. They are gearing up for a rematch of last season's championship game against San Diego State. And UConn and NC State are 2 of the 4 schools with both the men and women's teams still in it, along with Duke and Gonzaga.